The U.S. Supreme Court again backed President Donald Trump's hardline immigration approach on Monday, letting agents proceed with Southern California raids targeting people for deportation. A dissenting justice said the decision makes Latinos fair game to be seized at any time. The court granted a Justice Department request to put on hold a judge's order that had temporarily barred agents from stopping or detaining people without reasonable suspicion that they are in the country illegally by relying on race, ethnicity, or if they speak Spanish or English with an accent, among other factors. These roving patrols, conducted by Immigration and Customs Enforcement, ICE, agents, were part of an operation targeting individuals with final deportation orders, though critics argued the tactics swept up many without such orders. The administration quickly vowed to continue the patrols. The Supreme Court's 3 liberal justices publicly dissented. The administration has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction, Justice Sotomayor wrote in the dissenting opinion. Rather than stand idly by while our constitutional freedoms are lost, I dissent, Sotomayor added. Los Angeles-based U.S. District Judge Mame Frimpong found on July 11th that the Trump administration's actions likely violated the U.S. Constitution's Fourth Amendment protection against unreasonable searches and seizures. Her ruling was based on extensive testimony and evidence presented in the class action lawsuit, including numerous affidavits from plaintiffs detailing their experiences. The judge's order applied to her court's jurisdiction, covering much of Southern California. The Supreme Court's order was brief and issued without any explanation, a common way it handles emergency matters, but one that has generated confusion in lower courts and criticism from some of the justices themselves. The court has a 6-3 conservative majority. Then U.S. Attorney General William Barr called Monday's decision a massive victory, writing on social media that immigration enforcement officers now can continue carrying out roving patrols in California without judicial micromanagement. A lawsuit challenging the raids accused the administration of using roving patrols by masked and heavily armed agents who have conducted interrogations and detentions based on racial profiling that resemble brazen midday kidnappings. Individuals with brown skin are approached or pulled aside by unidentified federal agents, suddenly and with a show of force, and made to answer questions about who they are and where they are from, the lawsuit stated. A group of Latino people caught up in the raids, including some who are U.S. citizens, filed the proposed class action lawsuit in Los Angeles federal court in July. The named plaintiffs included day laborers, construction workers, and a U.S. citizen who was detained while doing landscaping work at a client's home. Mohammed Tassar, an attorney at the American Civil Liberties Union of Southern California, who helps represent the plaintiffs, vowed to continue to fight the administration's racist deportation scheme. This decision is a devastating setback for our plaintiffs and communities who, for months, have been subjected to immigration stops because of the color of their skin, occupation, or the language they speak, Tassar said. One plaintiff, Pedro Vasquez Perdomo, said in a statement that he joined the case because what happened to me is happening to others every day just for being brown, speaking Spanish, or standing on a corner looking for work. He said that agents did not explain why they grabbed him and that they did not have a warrant. I was treated like I didn't matter, locked up, cold, hungry, and without a lawyer. Now the Supreme Court says that's okay? That's not justice. That's racism with a badge, he said. Concurring with Monday's decision, conservative Justice Brett Kavanaugh said that apparent ethnicity alone cannot furnish reasonable suspicion, but it can be a relevant factor when considered along with other salient factors. This reasoning drew immediate criticism from civil rights groups who argued that sanctioning ethnicity as a factor effectively greenlights racial profiling. Kavanaugh added, if the officers learn that the individual they stopped is a U.S. citizen or otherwise lawfully in the United States, they promptly let the individual go. Critics pointed out that this fails to address the trauma, fear, and economic harm caused by unlawful detentions, even if they are temporary. Trump's administration has repeatedly asked the Supreme Court this year to allow it to proceed with policies that lower courts have impeded after casting doubt on their legality. This particular case was part of a broader pattern of the administration seeking and often receiving emergency relief from the Supreme Court to implement controversial policies blocked by lower courts. The court has backed Trump in most of these cases. For instance, it has allowed Trump to deport migrants to countries other than their own without offering a chance to show harms they may face, and to revoke temporary legal status previously granted by the government on humanitarian grounds to hundreds of thousands of migrants. Trump won election last year to a second term as president with promises of record-level deportations. His administration's immigration raids, including in Los Angeles, have prompted panic in immigrant communities as well as protests, and have drawn lawsuits over aggressive tactics. Community organizations in Los Angeles responded to the raids by setting up emergency hotlines and conducting Know Your Rights workshops. Trump sent National Guard troops and U.S. Marines into Los Angeles in June in response to protests against the federal immigration raids, marking an extraordinary use of military force within the United States to support civilian police operations. The deployment was authorized under Title 32 of the U.S. Code, which keeps guardsmen under state control but with federal funding, though the move was widely seen as federalizing a local law enforcement issue. Local officials and California Governor Gavin Newsom, a Democrat, contested the deployment as unlawful and unnecessary. Newsom stated, "This is nothing more than a political stunt designed to stoke fear and division in our communities." Frimpong issued the temporary restraining order, halting stops or arrests based on race, presence at a particular location, such as a car wash or tow yard, or type of work to establish reasonable suspicion of illegality. The judge was appointed by Democratic former President Joe Biden. Despite the Supreme Court's stay, the underlying class action lawsuit, Vasquez-Perdomo et al. V. Barr et al., continued to proceed in the lower court to determine the legality of ICE's tactics. The San Francisco-based 9th U.S. Circuit Court of Appeals on August 1st refused to lift Frimpong's order. The Ninth Circuit's denial was a key reason the Trump administration took its emergency application to the Supreme Court.